how do we actually obtain the appointment of a receiver? Well, the appointment of a receiver is subject to the New York Civil Practice Laws and Rules, Section 6401. And the standard states that the appointment of a receiver, in order to get one, since a receiver is considered to be an extraordinary remedy that we don't just give out, we're not able to do this by a standard of clear and convincing evidence, then they're not going to be able to obtain a receivership. If you came to our law firm, or you went to any law firm and said, I'd like to file an order to show cause, or I'd like to move to not only sue a CEO or a business partner of mine, I have to have standing to do this, so I need to be a shareholder in the company, or I need to be one of the members of the LLC, and I'd like to sue them for a litany of causes of action, well, then we can talk about filing for a receivership. And how do we do that? So you get your summons ready, you get your complaint ready, where you unpack all of the factual details of what's taken place. You set forth all the details of what's happened to date. Then you list your causes of action, the unjust enrichment, the fiduciary breaches, the misappropriation of corporate assets or corporate opportunities. You move on to claims for fraud potentially. And then instead of just filing that lawsuit and serving it, which puts the parties into litigation, you then file what's called an order to show cause for appointment of a temporary receivership. And through that lens, that order to show cause is sort of like an emergency application. You're running into court. You're saying, Your Honor, we need this to be addressed immediately.